Is it Jennifer Josky?
Yes, it is.
My name is Judge Sara Smolenski. I have you on the Zoom right now. Do you have video capacity or not?
Oh, I'm sorry, Your Honor. I just have one of these little chat phones. They're
That's
just
fine.
cheap. Oh, thank you. Thank
That's
you.
fine. Okay. Your audio is a little bit mixed up. I don't know if you're hand holding your device or if you could just set it down and speak.
Oh, okay. I'll move my hand away from. Is that better?
Slightly.
Is that better? Oh.
Do you have it on speakerphone?
No.
Okay. Here's what we've got. Your case was when you got arrested for the car accident back in July 20th, near the US 131 Expressway at West River Drive. I said car accident and I was wrong.
Okay.
It was not a car accident, and you know it better than I because you were there. You got pulled over on the expressway. You got pulled over on the expressway for speeding.
Yes.
We're getting a little feedback, so I don't know. Are there other people with you?
No.
Okay. And no music in the background. Okay.
Music? Oh no. I don't
Okay.
hear anything. This phone it's not a good phone. It's terrible. The few times
It's okay.
I have used it. Oh, I'm sorry.
It's okay. It's working. I'll just go through what I have to go through with you, Ms. Josky. Do you say your last name Josky?
Yes.
So the charge was originally operating with a high BAC, a 6-month misdemeanor. When you spoke to the prosecuting attorney, they were willing to reduce it to an operating while intoxicated. Operating while intoxicated is a criminal misdemeanor, up to 93 days in jail, up to $500 fine, court costs on top of that. You can, Ms. Josky, plead guilty or not guilty. You can have a trial in front of a judge or a jury. You can have an attorney represent you. If you cannot afford an attorney, the court can appoint one for you. Because you're unrepresented today, it's just you and me talking to each other. You won't have an attorney, and if you plead guilty, you won't have a trial. Giving up a trial means there'd be no testimony at all. No witnesses would come in, nobody testifies. You'd give up your own right to be a witness or to testify, and you'd give up your right to be presumed innocent until proven guilty beyond a reasonable doubt. Are you right now on probation or parole anywhere else, dealing with any other courts?
No.
Okay, not. And if there was something that you wanted to appeal or something that you didn't understand, you'd have 21 days, 3 weeks, after being sentenced to appeal to a higher court. Any questions you can think of so far, Ms. Josky?
I'd like to hire a court to help me right now.
None that you can think of?
I'm so nervous. I don't think I can think of anything.
Yeah, that happens.
Thank
take
you
a
for
couple of-
understanding.
Just take a couple of deep breaths. I don't want you to be too nervous. Obviously, it's not an easy position to be in. Probably harder. Probably harder when you got arrested and went to jail that night.
You're not kidding. I'll never get over that ever. ever.
This is a case where you got charged with operating while intoxicated, and you have to decide how you're going to plead, whether you were driving a car with too much alcohol in your system. So going back to the incident and thinking about it, knowing that the charge now is operating while intoxicated, the misdemeanor, how do you want to plead to that, Ms. Josky?
Well, unfortunately, it is the truth. I never thought anything like that would happen to me. This business of alcohol it's completely not an issue, especially in our family, because I live with my dad, and
Yep.
he had a pacemaker put in right when I got out, and he literally had to have emergency surgery. He actually could have died. He could have died that night. He could have, but he cannot. He used to have his dinner drinks, and he can. There's not a drop of alcohol. He cannot. Neither of us. And I don't even care about alcohol.
Ms. Josky,
but we did.
can I interrupt, Ms. Josky?
I did
Ms. Josky?
drink that night.
Ms.
I
Josky,
was. Yes.
Ms. Josky, can you hear me? Hold on one second.
Sure.
You're telling me a whole lot of stuff about your dad. You're telling me a whole lot of stuff about you. And my
Yeah.
question was, how do you want to plead to operating while intoxicated, the misdemeanor? Your choice is not guilty or guilty.
Well, I have to be honest and say, yes, I was drinking. Yes.
So how do you want to plead?
Guilty.
And are you pleading guilty by your own decision?
Well, yes.
Has anybody forced you to do it?
No, nobody forced me to do it, but
How old are you?
56.
Repeat that.
15.
56.
You're 56 years old, so nobody's forced you to do this, Ms. Josky?
No.
And the date of that incident, where were you drinking?
Oh, I was in the backyard of the house.
Were you by yourself?
Yes.
No other people?
Nope. By myself.
And you drank, what alcohol did you drink?
I was drinking champagne because I can't drink hard liquor, and I was upset over an argument.
Did you
with
have
my
any
dad.
alcohol other than the champagne?
No, just the champagne, but I had too much.
No wine?
No, just champagne.
And why did you have to drive?
Oh, I got into an argument with my dad.
Why did you have to leave? Where were you going?
I really didn't have anywhere to go.
Nowhere.
I was just thinking of just parking somewhere, and then I just wound up driving aimlessly. And
On the highway, they said you were going 91 miles an hour on the US 131. And you don't even have anywhere to go. You're just driving aimlessly, like you say.
Yes,
And your blood alcohol level, way over the legal limit. Do you remember what the number was when they tested you?
I was inside the police station when he put the breathalyzer, whatever that is, in my mouth. And
Do you remember what it was? The
I
result.
I was too nervous to remember what the number was. I was just so nervous. Yeah.
0.17. 0.17 on the breathalyzer.
Oh.
Showing
I'm
that
so
you had
ashamed.
way too much alcohol in your system.
There's no question about it. I most certainly did. The funny thing is it's not funny, but I can remember every detail of everything. And I did know I was going too fast, and I thought, you're going too fast. And I was fumbling around for, I don't know, something on the passenger side, and I thought, I'm going way too fast. And then I was going to slow down. Honestly, I was. And then I all of a sudden the flashing lights behind me, and I just pulled over real smoothly and calmly. I remember everything, every
Can
single
you
detail of
imagine?
this.
Can you imagine if something worse were to have happened? Can you imagine how bad
Yet,
it could have been?
yes, I thank God and the protection of the angels, because to think about what could have happened, to someone else, or
Right,
or myself even,
right,
or animals. I
right.
if or hitting a deer or killing an animal. That's actually what started me to drink, is over an animal. It's
Ms.
I know you don't
Josky,
have.
do you work?
I did work until the layoff, until the
Okay.
COVID. We were
And what
laid
are you
off, but
doing
I
now?
did. Right now, I'm just helping my dad out, because after his pacemaker, he, you know,
Is your
doing like
mom
the.
deceased?
Yes, yes.
Okay,
She passed away 2017, June 10.
okay. I'm sorry. Ms. Josky,
Thank you.
I accept your plea of guilty to this charge, but we want to avoid it happening again.
Oh, it won't. Believe me. I,
I hear
I,
people say that all the
oh, I
time, but you
know.
need to be aware
Mhm.
that this
I know
can't
that.
happen again.
Oh, believe me. As God is my witness, I know you've heard everything, and that's what people do, is they say, "Oh, I'll never do it again. Oh, I'll never." Well, with me, uh, I'm a not only do I really don't even like alcohol. We can't drink in our house, and right on the right after my dad uh, got home. Well, the same day he came home from the hospital, I had to call the nurse from my doctor's office, and she gave me some bad news that I am a sugar diabetic now.
Uh-huh.
And so even if I wanted alcohol, which I don't even care, I could care less, especially after what happened to me. I don't care if I ever see a sip. I don't care. Uh, and I am a diabetic, which is, it's very scary. I just found out more details about this illness, and it's just horrifying. And I can't, even if I wanted to, which I don't. I couldn't. We don't drink in the house anymore. We're both. That's it. It's over. It's over.
Yeah.
And
All right, here's
and
what I'm going to do. Ms. Josky, I'm sentencing
yeah.
you now. So listen to what the penalty is. You'll have to be in contact with our probation department. They will contact you at the Michigan Street address where you're living. You don't go to jail unless you mess up.
Okay.
It's a 93-day suspended jail sentence. 92 days are suspended, 1 day credit for when you went to jail. You're going to be required to do 12 days of community service. You'll be on probation for 1 year. Absolutely no alcohol ordered by the court. No illegal drugs. No misuse of prescription medication. No marijuana. They're going to order you to do counseling. The monetary fines are expensive. It's $730 on the charge. $360 is the fee for probation at $30 a month times 12 months. $75 crime victims' right fee. $175 goes back to the Michigan State Police. Your total is $1,340.
Oh, dear
Your
God.
driver's license is going to be taken away by the Secretary of State. They'll
Taken
set up a
away.
payment plan. They'll set up a payment plan for you to take care of this. There was no bond money posted, so you'll have to set up a payment plan. And the probation officer will talk to you about setting up everything you need to do.
Now, you said, I'm sorry, this, I heard heard most of it, but do I have time to ask you a few more questions?
Yes?
Now, let's see. I do not have to go to jail.
No, you don't have to go to jail.
Thank God. And
Ms. Josky,
yes?
the probation officer,
She tells you, like, she gets whatever,
the probation officer will be in contact with you.
get in trouble for.
And all of this will be explained to you in detail about how to pay your fines, how to do your community service.
So everything you told me, she will tell me again?
Yes, yes,
Oh,
he
good.
or she. Yeah,
Okay, I'm so nervous, and it's also.
I get that. I get that. You've said that. I understand.
Yeah.
I do appreciate that you hooked up with Zoom and that we could talk this morning to take the plea on the OWI and the sentence. We will contact you, Ms. Josky, and if you have any questions, you talk with your probation officer.
Okay, and I'm scared to ask this, but did I hear you? Did you say I'm going to lose my license?
Your driver's license is affected by the Secretary of State. They take your license away based on what your master driving record looks like. When you get a drunk driving case like this, the Secretary of State will send you a letter. Usually they suspend it for a month.
Oh, dear
Sometimes
God.
they take it away for longer, depending on what your record looks like. Then they give you a restricted license to drive for a certain period of time, for only certain purposes. You'll be able to talk with your probation officer about it, but you'll also be able to talk to the Secretary of State as well.
Oh, I wish I never got up in the morning on June 19. Wish that day never existed.
But think of it like this, Ms. Josky, just like you said. It could have been a lot worse.
Yes.
Deal with this one step at a time.
Okay.
But don't repeat it.
Don't worry. Believe
Okay.
me, it's not. I'm not laughing. It's not funny.
No, I understand. I understand. Yeah, I understand. Listen, I've got to get to the other cases. I've got to get to the other cases, so I got to sign off.
I'm sorry I took up so much of your time.
No, you're fine. You're fine, and you had good questions. You had good questions. But now you can disconnect, okay?
Oh, okay. Thank you
Right,
so much, Your Honor. Thank you so much, Your Honor. Thank you.
You bet, Ms. Josky. Okay.
Thank you. Will you have a wonderful day? Thank you for everything.
Okay,
Bye.
thank you. Joseph
Thank you.
Costa.
Bye. You're welcome.
Amanda.
Bye.
Mr. Joseph Coster? Sir, that zoomed in with the red plaid shirt on? Your last name?
Is Ragster.
Mr. Ragster, Marquise?
Yes, ma'am.
Do you say it Marquise?
No, it's Marquez.
I'm sorry, I was saying it wrong. Mr.
No,
Marquez, Ragster, I've got you in front of me on a ticket that goes back. One ticket was a default. The ticket itself goes back to February 8 in a 2008 Jeep, where you got ticketed for having marijuana plants. Does that ring a bell?
Marijuana plants?
Some kind of plant.
No, I didn't have any marijuana. I might have had some marijuana weed, but I didn't have.
That's what it is. That's what it was. Do you remember the ticket?
No, I don't actually.
You don't remember getting a physical ticket from the police on February 8 at Patterson and 28th Street?
Patterson and 28. Hold on one moment, please. Can I ask my dad about this?
Sure.
'Cause I don't. Dad, you remember me getting a ticket on Patterson for some weed?
Yeah.
That's what I'm saying.
You did?
Yeah, I
You
don't.
only have the one on Plainfield.
Yeah, that's what I thought. That's what I
You didn't
thought.
even have weed.
Yeah. I I only remember the one from Plainfield. I was driving on Plainfield, and I turned into a neighborhood, and they caught me with some weed. But
Mr.
I don't.
Ragster, I'm not
Yeah,
doubting that it could be something you don't remember. I think this was kind of a time period perhaps that's quite a long time ago, February 8. It's 8 months ago, but it was a ticket with you in a 2008 Jeep, white in color, at Patterson and 28th Street. They had your date of birth down as 10/12/99. So you're coming up on your, what is it, your 21st birthday?
I know what you're talking about. I didn't think I got a ticket that day, but yeah,
Okay.
I'm my
Can I
21st.
just ask you, are you coming up on your 21st birthday?
Yes, ma'am.
Okay. So the ticket was a civil infraction ticket. I'm just here to tell you, it's not a criminal case. It's not. It's a civil infraction, and it's defaulted a long time ago, and it's $125. What I'm here to talk to you about today is what happened at that Crown Plaza back on the date of June 10. And the charge was originally pulling a fire alarm falsely and disturbing the peace. The prosecuting attorney said if you pled to pulling the firearm falsely, they would dismiss the disorderly peace case, the disturbing the peace. The false fire alarm is a misdemeanor. It's a criminal case. And Mr. Ragster, it's up to 1 year in jail. It doesn't mean it will happen. It just means that's the maximum penalty. 1 year in jail and or $1,000 fine. Again, it doesn't mean that's what the fine would be, but that's the maximum. You don't have an attorney. You're handling this on your own. And while I heard you earlier talking to your dad, that's fine. But the final decision has to be yours, not your dad, not your mom, not me. Pulling the fire alarm when you're not supposed to is a misdemeanor. And you have the right to plead guilty or not guilty. You have the right to have a trial in front of a judge or a jury. You have the right to have an attorney. If you go forward on your own, you're by yourself, then you make your own decision. No attorney, no trial. If you go forward on this case, Mr. Ragster, you either have to admit that you pulled the fire alarm or fight the case and say you did not. Having said that, if there's something you didn't agree with or you took issue with, you'd be allowed to appeal. At the district court, all the appeals go to circuit court. Circuit court is the next higher court, and you're given 3 weeks after being sentenced to appeal a case to the higher court. Now, just with what I've said, does it make sense to you? Do you have any questions?
Yeah, I understand. I like to plead guilty.
When you look back on this and you understand what happened, it wasn't one of your best days, it sounds like. Going
No,
back to the date, yes?
I was
I'm sorry.
I was having a mental episode that I went
Sure,
to
sure.
Forest View,
Which is
Florida.
why your mom took you there in the first place, right? Your mom took you there so then your dad would pick you up?
Yeah, because I was having a mental episode at the house.
Are your parents separated?
No, they're together still.
Okay. So if we go back to June 10, and we're talking about what happened at Crown Plaza, including the fact that you were having a mental episode and having an experience that's not the way you normally conduct yourself, there are parts of it that you remember, correct?
Yeah, and I do have paperwork for being at Forest View too, by the way.
I'm not doubting it. I believe you without seeing the paperwork. I get that this was a mental episode. June 10 at Crown Plaza, how do you want to plead to pulling the fire alarm falsely?
I would like to plead guilty.
And are you pleading guilty by your own decision?
Yes, ma'am.
Nobody's forced you to do that, correct?
Nope.
Nobody's made you do it. Okay. So the day that you were at Crown Plaza, your mom took you there because you were having a rough go of it, correct?
Yep.
And then your dad was going to come, but for a while you were there by yourself in the room, true?
Yeah.
And when you tried to use the vending machine and it took your money and didn't give you the product, that was a source of frustration, as it would be for any of us, true?
Yeah, yep, that's
So you
exactly
went
how.
to the main desk to find out what you were supposed to do about getting your money back, and things didn't work out exactly the way you wanted, correct?
Yep.
And the lady at the counter, wasn't able to help you like you wanted. And at some point in your frustration or in your mental state, you pulled the fire alarm.
Yeah, it kind of put if I don't know. It kind of put me like when I asked her for my money, she wasn't really like real helping with me. So it kind of
Yeah,
like it was like a more of an angry, like a panicky,
right.
like an anger,
So
panicky
because you were
feeling.
frustrated and
Yeah,
angry towards
started.
her and her lack of help to you, you decided out of frustration and anger, you'd pull the
Mhm.
fire alarm, even though you knew clearly there was not a fire. True?
Yeah, yep.
Okay. And when did you go to Forest View then, or Pine Rest right from there?
Um,
Did you go to the jail? Did the police pick you up?
I went that Monday, but no, the
Okay,
police, the police did pick me up. I apologize.
okay. So you went to jail, and then after getting out of jail, you went to Pine Rest or Forest View?
Oh, I didn't go to jail. I went to the police picked me up and took me to the hospital, and then
Good.
from the hospital I went to straight to.
So you went to the hospital, the psychiatric ward, and then you went to Forest View?
Yep.
Okay. You're on medication now, correct?
Yes, I am taking my medication.
And things are better than they've been before now, correct?
Yep. Things are getting better
And you
for me.
live with your mom and dad?
Yep.
And that's the Shiloh Pines address?
Yes, it is.
Do you go to school, Mr. Ragster?
No, I don't go to school, but I do work Monday through
What
Saturday.
job?
I work at Maryland's Dog Grooming. It's a dog grooming
Yeah,
place,
that's
and
fine, great. How many hours do you put in?
I work 8 hour shifts every day. I don't know how many hours that is a week.
Do you work all the time, like 5 days a week or more?
Yep, I work 5 days
Okay.
or six
How
days.
often do you see your medical or your doctor for your medications that you're on, for your mental health stuff? Are you seeing a therapist? Do you see a counselor?
No, I'm not seeing a therapist. They just put me on medication.
Uh-huh. And what's your age? You'll be 21 here in a week or so, 10 days.
Yep.
Okay, so when you turn 21, I don't want you to be using alcohol.
Yeah, no, I'm gonna stay. I'm not
I
really
mean, a
like.
lot of people want to celebrate when they turn 21 and get loaded or start using alcohol. You're going to be on probation to us, Mr. Ragster. One of the rules is no alcohol, no matter what, if you turn 21. I don't want you to celebrate. I mean, you can celebrate, just don't use alcohol. No illegal drugs. No
All right.
misuse of your prescription medication. We want to follow up on your mental health therapy to make sure you're doing everything you're supposed to be doing. Are you with me?
Yes, ma'am.
You're going to be contacted by the probation department. They're going to be contacting you directly to set all of this up. I'm
All
not
right.
wanting you to do community service. I'm more interested in you getting your mental health stabilized. But
All
when
right.
you were at Crown Plaza, even though that lady wasn't helping you the way you wanted, how you acted was scary to all of them. I don't know if you get that exactly.
Well, after the fact, I really didn't do anything. After I like pulled the fire alarm, I didn't
You
do anything.
just you just stayed there and you sat down and called 911 yourself.
Yeah, I was more like
Yeah.
in the day, so I was like, I just didn't.
But you know what I'm saying? When you jump over the counter and you pull the fire alarm, it's scary to them.
Yeah, I understand that.
And then she's got to tell all the people that are there that have nothing to do with anything, they're just staying at the hotel. She's got to tell everybody that works there, everybody that's visiting there, everybody that's staying there, all the people that are in the rooms, this is a false alarm. You know, and that's hard. That's why
Yeah.
we don't want anybody pulling a fire alarm when it's not needed. That's the whole point. Okay, so what's going to happen is you get a $500 fine You're going to be on probation for a year. They want to watch and make sure you don't have any new offenses. Stabilized is what we want. It's a $180 fee, I did it last, Amanda, for the probation. $75 is the crime victim's right fee. Total is $755 on this case. Plus you owe the $125 from the other case that I was telling you about that you don't remember. So the total is $880 altogether. You're going to have to set up a plan to pay that, and you can talk to the probation officer about it when they contact you at your mom and dad's house. Now, can you think of any other questions that you have for me, Mr. Ragster?
No, ma'am. Not
All
at the
right.
moment.
I really appreciate that you zoomed in. I know you were waiting when I was talking to that other lady. I just want you to be crime-free, okay?
Yes, ma'am.
Any questions?
No, ma'am.
Okay, all set. Thank you.
I appreciate you. Thank you.
All right, thanks a lot. You take care. Stay healthy.
Yep.
All right. Mr. Barracks, are you part of the video today for the Zoom? Ms. Collins, we'll be back with you in a minute. Just hang on. Can you just put her mute? I don't know where that's coming from. Mr. Barracks, can you hear me? Okay, he's not on then. Ms. Collins, can you hear me? You have to unmute yourself. Okay, thanks. Mr. Worth, can you hear me?
Yes, Your Honor. We're prepared to proceed.
That's fine. We have Ms. Mariah Collins in front of us on the Zoom, file D20-00921. Ms. Collins, you're probably going to remember back to March 15. It's already almost 7 months ago. Wolverine and Belding Road up in Plainfield Township. The car accident that occurred at that location. You got a warning on a failing to yield the right-of-way, and you were arrested on the operating while intoxicated. Somehow, Mr. Worth worked out an agreement with the prosecutor that if you pled to an operating while visibly impaired, they'd drop the operating while intoxicated. Mr. Worth, was that your understanding?
That's correct, Your Honor.
And Ms. Collins, is that what you talked with your attorney about?
Yes, it is.
Operating while visibly impaired is a criminal misdemeanor. It's up to 93 days in jail. It's up to $300 fine. Court costs can be on top of that, and it gets to be very expensive. It's 4 points on your license if you pled guilty or were convicted. Secretary of State can take your license away, suspend it, restrict it, or revoke it. You have the right to plead guilty or not guilty, Ms. Collins. Have the right to have a trial in front of a judge or a jury. Have the right to have an attorney. If you can't afford an attorney, the court can appoint one for you. Then you pay the expense of a court-appointed attorney. Mr. Worth is here as your attorney of record and more than capable of representing you. You have to be the one, however, to make the decision to plead, not your attorney or not me or not your family. You'd be giving up your rights at trial, like to bring in witnesses, cross-examine witnesses, take the stand yourself, be a witness if you wanted to. If you chose not to, your silence cannot be held against you. And you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Now, if you do go forward today, Ms. Collins, there's no trial. And then you'd give up your rights that are associated with having a trial. Do you understand that so far?
Yes, ma'am.
Are you on probation or parole?
No,
Do you have cases in any other courts that you're dealing with besides this?
I do not.
When you go back to this case and think it through, while there might be some of the things you remember and some you don't, The decision that you make has to be yours about whether you were operating with too much alcohol in your system. Anything that you'd want to appeal, or if there was anything you didn't agree with, you're given 21 days from the date of sentencing to appeal a case to the higher court. Any questions about that?
No, ma'am.
So going back to March 15th, not quite, but almost 7 months ago, Plainfield Township, Wolverine Drive and Belding Road. How do you want to plead to the amended charge called operating while visibly impaired, first offense?
I'm going to plead guilty.
Are you pleading guilty by your own decision?
Yes, ma'am.
Do you remember the incident?
I do.
Were you driving?
I was.
Was anyone with you?
No, I was driving by myself, ma'am.
Was the BMW a car you're familiar with?
It is.
Did you go right through a red light and hit another car?
I did.
Do you remember seeing it, or was it last minute, or how did it happen?
It was last minute, ma'am.
Uh-huh.
Yeah, I was.
Were you physically hurt?
I was not.
Banged up?
No.
Was the other person, were there more people in the car? Do you know how many?
There was 2 other people in the vehicle that I hit, and
Do you know if they were hurt?
No, not at all. Thank God.
And the police came to the scene,
Yes.
and they talked to you and they talked to the other people,
Yes.
and you had tests taken? Did you have blood taken from your body to test it?
No, I did not. They did a breathalyzer.
Did you take a breathalyzer where you blow into a machine?
Yes, I did, ma'am.
Do you do that at the scene with a PBT and then down at the station with a regular machine?
Yes.
Do you remember what the results were that showed how much alcohol was in your system?
0.09.
Yeah. And the PBT was a 0.10?
Yep.
And you realize that both a 0.09 and a 0.10 are over the legal limit?
I do.
Where were you drinking?
It was a little bar. I was drinking at a friend's house. I had a beer there, and then we went to a little bar. I can't
Was
remember.
it just you and the friend?
No, there was a group of us.
How many?
About 6.
When you drove to the friend's house originally, were you by yourself?
Yes.
Did you take alcohol or drink it once you got there?
Once I got to my friend's house. Yeah.
Yeah, did they provide it to you or did you take it?
They provided it, yes, and I had a beer there.
So they provided alcohol and then you left that house after drinking. How do you get to the bar?
We walked to the bar.
So you walked to the bar from your friend's house
Yes.
and you drink more alcohol there?
Yes, ma'am.
Presumably when you leave with the other people, friends, you walk back to the person's house?
That is correct.
And at some point you decide you get in your car and you're going to drive to go home?
Yes, I had some food, and then I waited a few hours, and I thought I was going to be fine.
And is Watkins the address that you were going back to
That is correct.
when you had the car accident?
Yes,
Today, are you pleading guilty by your own decision?
I am.
And you realize there's not going to be a trial?
Yes, ma'am.
Mr. Worth, do you believe the court has complied with the court rule in terms of the taking of the plea on this case?
Yes, I do, Your Honor.
Anything you want to say about Ms. Collins that you might want to talk about regarding this case? The
that a question?
assessment was done out of that Florida place? Why
Yes, Your
was
Honor.
it Florida?
Your Honor, are your questions directed to me at this point? I'm sorry.
Either.
So Ms. Collins resides in Florida. She's established residency down there. She works full-time for in the insurance industry now. She was able to get insurance industry employment rather than food service server employment, which was her prior occupation. I think that that's a great step for her with respect to kind of taking her out of an environment that sometimes promotes substance issues. So now she's in a different occupation and a different environment. She's been employed there steadily for the past 5 months.
Okay, 5 months she's been in Florida, so it wasn't that far after this that she moved, correct?
That's correct, Your Honor. The court may recall, in looking at the court file, that there was a substantial period of delay
Okay.
from the citation and her arraignment.
Okay,
And she was released with the $100 bond from the sheriff's office, which did not contain, as the court would be aware, bond conditions restricting her movement or her behaviors. And so she thought she was fine to move to
all
the
right.
state of Florida and take up residency there, which is what she did.
All right, that's appreciated. Mr. Worth, what was the typographical error you wanted to correct with the assessment?
Yeah, thank you for raising that, Your Honor. It is on page, it is on page 2, Your Honor. This would be under the heading substance use. The next line
Yeah.
says alcohol. The next
Yeah.
line after that says Miss Collins states she has no time, completely sober. And what the evaluator meant that to convey was that Miss Collins states she has no time, as in her schedule, to drink excessively. And
Right.
she is, and so she is completely sober in the sense that she doesn't report that she's becoming intoxicated. We tried to get that typo corrected, but we only received the report yesterday. We
Yeah,
reached
okay.
out to the
I
assessment
get it.
center.
All
So,
right. Anything else you can think of that you want to say, Mr. Worth?
yes, Your Honor, I would. I just, my client absolutely takes responsibility for everything that happened, and this involves, accident with another vehicle, and she does not dismiss any of that. I do think that it was Miss Collins' intention to act responsibly, in that she did take a period of several hours after consuming, 4 or 5 drinks. She did take a period of a couple hours and have some food, and she felt that she was no longer influenced by the alcohol and was no longer impaired to drive. Obviously, the chemical test says differently, as does the impairment that caused the accident. However, she was at a 0.09 level, and so this is, I think, distinguishable from a case of somebody who would pound their last shot at the bar and walk out the door with the car keys. She did try to take a responsible step. She's otherwise a responsible person. This is a first offense, not only on an alcohol-related driving charge, but of any criminal activity whatsoever. She's well established down in Florida. She's got a responsible job. She's maintaining steady employment. And Your Honor, we would ask that the court enter an order for fines and costs in this particular case, particularly with the geography that would be involved in probation. However, if the court's inclined to enter an order of probation, we would ask that Ms. Collins be able to do that remotely. I think that the district court's probation department is set up to do that even with Michigan probationers right now, and that Ms. Collins complete that sobriety class that's identified in the substance abuse evaluation and complete the terms of her probation in that way. Under any event, we would ask that she not be ordered to come back to the state of Michigan and not be ordered to serve any period of time in jail.
All right, thank you, Mr. Worth, for your preparedness. Ms. Collins, can you think of anything you want to say?
As I said, I fully take responsibility for the accident and my inability to properly determine how impaired I was. And I have taken steps to move forward. Part of the reason why I have moved down to Florida and pursued this job in life insurance to kind of avoid those situations, environment all around. I'd say that.
Do you mean like get away from that group of friends?
That environment overall, yes, ma'am.
Had you been thinking about moving to Florida before this all happened?
No, not exactly. This opportunity came along, and I
How
thought
did it connect? How did it connect? How did it happen that you just all of a sudden moved to Florida?
my mother actually lives in
Okay, so that makes sense. All right.
Yeah.
Well, here's the deal. Try to picture your mom or your dad, wherever he is, or anybody that cares about you. Try to picture that on March 15th, they had to be contacted because you were killed in a car accident? Because to me, that's what this is like. The what ifs, what if it wasn't? Or what if you didn't die, but you killed those people in the other car? Today's Friday, the 2nd of October, last Friday, whatever it was, we had 2 fatals in our court. And I dealt with 2 different cases, totally different set of facts, totally different set of everything, 2 totally different people that were killed, but a fatal and a fatal. And I'm telling you, honestly, Miss Collins, those are the hardest cases. Picture yourself thinking that you weren't impaired, thinking that you could drive home. Never in a million years were you planning or sorting out that you were going to put people's lives at risk, including your own. And yet the result, when you run a light, you slam into the guy's driver's door, this has fatal written all over it. And it didn't happen. And we all want to say, thank God it didn't happen. I mean, don't hear me wrong. I don't want you killed any more than I want the other person killed. I don't want anyone killed in a car accident. I wish we could make that happen. Nobody could be killed in a car accident. And I'm not even talking about every case where there is alcohol involved. Sometimes we got nothing. And they still go through the same red light you did. They were looking at something else. They were distracted. They didn't see it. How do you explain it? How do you explain that you went straight through a red light and slammed into this guy's driver's door? And my point is, this doesn't make you a bad person, but you have to revisit seriously how you conduct yourself. If you're, 22 years old, and you let this happen, it is completely irresponsible of you. There's really no one else to blame it on but you. You're an adult. Deal with it. From what you've said to me, you've taken notice that this was really inappropriate for you. It wasn't something you intended to do, but it happened, and you walked away. Other than the cars being totaled or whatever happened with them, you walk away unscathed. Physically, I mean, your physical health. Thank God, so did the other people, according to what you're telling me. Try to imagine these cases where it's not that. Try to imagine the cases where there's a brain injury, and they're never the same. I mean, I've already talked about the fatals. That's pretty much the end right there. There's no turning back the clock when it's a fatal. But if the guy tears his left leg off and he's now an amputee because they couldn't save it or whatever, I mean, there's so many different things that could have happened here that would have been a zillion times worse. I think of those first responders that get to the scene, because one of our cases, a guy was stuck in the car, and he died. I mean, he died. And I'm saying, you can't even imagine how much this impacts people when there's a fatal car accident. And nobody more so than the family of the deceased. They all have to be called. That's why I'm saying, try to picture your mom down in Florida last March. She heard about your car accident. I'm sure she did hear about the whole thing. And I'm sure it scared the hell out of her. But try to picture she's getting a call, it's your worst news ever. And oh, by the way, Mariah's gone. Because that can happen. And it does happen to families. And all I'm saying is, there's no excuse. And while this does not define who you are, and I'm not sitting here trying to beat you up about what you did. I mean, geez, it's 7 months later and I'm talking to you now because of COVID and everything else. And I thought your comments were right spot on. I thought you got it. I thought you spoke maturely. And I'm hoping that you get it. Mm-hmm. And I don't care if you live in Florida or Timbuktu or Grand Rapids or Rockford. I'm just saying you have got to make sure you're strong enough to make good decisions and not let this repeat itself. I give you a 93-day suspended jail sentence where 92 days are suspended, 1 day credit for when you went to jail. I give you 10 days of community service to do that you'll be doing from Florida. We would never expect you to come back to Michigan for any of this. We deal with people that live all over the United States and beyond, and we still deal with them. And in our remote world we're in now more than ever, we can do all of this remotely. 1 year of probation, 1 year from now, if you finish everything successfully, it's very possible it would be terminated early. No alcohol, no illegal drugs, no misuse of prescription medication, no marijuana. We can have you tested down in Florida at any clinic that they would use for any of the Florida courts. And we just want to make sure that you get whatever counseling is needed so that you can be well prepared to make sure this doesn't happen again. It's $560 on an impaired. $360 is the probation at $30 a month times 12. $75 is the crime victim's right fee. $100 is the Michigan State Police fee. Your total on everything is $1,095. I expect that insurance covered everything with reference to the accident. Your car, their car, anything that got wrecked or damaged. I don't know, and I haven't followed up with any reports of that, but if a victim in an alcohol crash, the victim in the other car, had any damages that weren't paid for, we often will have you reimburse them. Just say, I don't know, insurance didn't cover something, or their laptop computer went flying out the window when you hit their car. I mean, we do have people pay restitution. Mm-hmm. And in the insurance business that you're in, although I recognize you said life insurance, insurance does cover a lot of this stuff. But if it doesn't, I keep that open, because all I want to do is put them back in a position as if this had never happened. Well, that's impossible, because they already experienced all the trauma with it. I can't change that backing up the truck. But if they had out-of-pocket expenses, we can make that right. We can make them whole. Now, do you have any questions for me, Ms. Collins?
No, not at the moment.
Okay. Mr. Worth, your client can be in contact with you if anything comes up, but our probation department will contact her directly. I want to make sure we have the correct Florida address. Can you make sure, Ms. Collins, that you're giving that to Mr. Worth and he makes sure he sends that information to my clerk? We're live streaming right now, so I'm not expecting you to give your address out for the world to hear, but you contact Mr. Worth. Mm-hmm. If you already have the updated Florida address, Mr. Worth, email it to my clerk, Amanda Dubay.
Very good, Your Honor. Thank you.
Any other questions?
No, Your Honor.
All right, Mr. Worth and Ms. Collins, thank you for zooming in today, and thank you for your time and attention. I feel like you both took it very seriously. And, you know, Ms. Collins, the next time you give your mom a hug, assuming you can during COVID, you know, let her know you got a do-over. Mm-hmm. There are a lot of people here that don't. And there are people in Florida that don't. I mean, it's everywhere. So be alert. Read the paper. Okay, that's it. Thanks so much. Appreciate your courtesy.
Thank you. Goodbye.
Uh-huh. What were you going to say, Mr. Worth? Oh, he's already gone. Okay. We'll take it. We'll take his. Well, who's the attorney on Lake? Defender's office? Let's just get him on. See if Abuxia is there. Is it Mr. Larrabee?
Lay.
Are you Mr. Lay?
Yeah.
Joshua Lay?
Yes.
Okay, good. I'm Judge Sara Smolenski. We're getting your attorney on so we can talk to him a minute, Mr. Lay.
Okay.
Who did you have from the public defender's office that you were talking to, Mr. Lay?
I'm not sure, ma'am.
Okay. We'll see who's scheduled to be here.
I met with my attorney yesterday, though.
Yeah, who is that?
Patrick O'Keefe, I think.
Okay. We'll
He
see.
said that he
who's-
was, yeah, he said that he was gonna be here this morning.
Okay, we'll see if he connects and then we'll see what's going on. Mr. Miller, what case do you have?
I have People versus Jeffrey Larrabee.
Yeah. We're not seeing Mr. Larrabee right this second, but are you expecting him to zoom in?
I am. I can call him right now.
You represent him?
Yes.
Okay. I think he's trying to connect right now.
Okay.
Mr. Miller, what's your P number?
69906.
You're so casually dressed, I thought you were, I didn't know who you were.
Well, here's the deal. I didn't plan on being here today, but my client insisted. I had another lawyer to cover it. I'm down in Florida. I typically
Okay.
wear a suit. but
Not a problem.
I'm
Not
here.
a problem. I wasn't trying to be problematic. I was just trying to say, because at first I thought you were a deputy. I wasn't clear. Okay, Mr. Larrabee, can you hear me?
Yes, I can.
It's Judge Sara Smolenski at the 63rd District Court. And Mr. Larrabee, you and your attorney, Mr. Miller, are both part of this Zoom meeting. On your file, that's D20-01199SD. And Mr. Miller was just advising me that he is in Florida on vacation and that he wasn't originally planning to be part of this, but you had really wanted him to be part of it. So I appreciate that Mr. Miller is taking his personal time to do this, but I get that he's representing you. And the case really turned out where Mr. Miller worked out an agreement with the prosecutor to have the original charge of OWI drop down to an OWVI. And that's your understanding, correct, Attorney Miller?
Yes, Your Honor.
So, Mr. Larrabee, if you plead, it's to a lesser charge. Operating while visibly impaired is still a misdemeanor, but it's up to 93 days in jail, possible, up to $300 fine, 4 points on your license if you pled guilty or were convicted, and the Secretary of State can take your license away pretty much based on what your master driving record looks like. You have to be the one to make the decision as to how to go forward, Mr. Larrabee. If you decide to plead guilty, it has to be your decision based on the facts of the case. So far, Mr. Larrabee, are you with me?
I sure am.
You know you can plead guilty or not guilty, as I said. You know you can have a trial in front of a judge or a jury. If you go forward today and plead, there's no trial. Mr. Miller is here as your attorney of record, so you're capably represented. If you go forward on your own, there's no trial. So we never have a trial if a person pleads guilty. So the rights that you give up are the rights that go along with having a trial, like bringing in witnesses, cross-examining witnesses, taking the stand yourself, being a witness if you wanted to. If you chose not to, your silence cannot be held against you, and you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. So far, Mr. Larrabee, do any questions pop out at you?
No, ma'am.
If you're going forward today and you didn't agree with something, you'd have 21 days, that's 3 weeks, 21 days to appeal to a higher court, that's circuit court. Do you understand that?
Yes, ma'am.
So if I go back to March 15th, and we're talking over 6 months ago, and we're talking about the address at Baumhoff and Skyview in Sparta, when you're working on your truck tire and a cop pulls up, or whatever happened, how do you want to plead to the charge they call operating while visibly impaired?
I plead guilty.
And are you pleading guilty by your decision, Mr. Larrabee?
Yes, ma'am.
Nobody's making you do it, true?
Correct.
You have a Silverado pickup truck that you own, or do you borrow it?
I no longer own it, but I owned it.
In
Yes.
March, was that the vehicle we're talking about?
Correct. Yes.
Was that a vehicle you owned at that time?
Yes.
Were you driving it on March 15th when it had its problem with the tire?
Yes.
Where were you coming from?
I was coming from a work party in Grand Rapids.
When you were at, what kind of work do you do?
I work at Chevrolet. I'm a sales representative.
Did you say Chevrolet, like the auto industry?
Correct.
Okay. So you're at a party, this is March 15th, it's not in coordination with any holiday, is it, or am I missing that?
Well, it was actually our work Christmas party that was postponed a couple
A
months.
postponed Christmas party? Okay, fair enough. When you're leaving the party, prior to leaving, you had drank alcohol at that party, correct?
Correct.
Presumably, alcohol they provided to you as part of the holiday party, correct?
Correct.
When you leave, is your destination home?
Correct.
Would that be the place in Muskegon on Monica Lane?
Yes, ma'am.
And en route, you had mechanical problems with your tire, correct?
Yes.
That's a funny way to say it, but you know what I mean. Okay, especially to a guy that works in the car industry, but you get my point. So you have a problem with your tire, you pull over, you start working on it, and the police pull up?
Correct.
And what time are we talking? Just ballpark. Is this lunchtime, dinner time, midnight? What are we talking?
Midnight.
Midnight? And are you by yourself in the truck? I mean, are you just traveling on your own when you get to that point to fix your tire?
Yes.
Okay. And then when the police come upon you, they ask various questions. Fair?
Fair.
At midnight, really, they're going to see if you need help, find out what's going on, start talking to you. At midnight, they're going to mostly ask any of us, regardless of our age, have you had anything to drink tonight or something like that? And they poked around with those questions, didn't they?
Yes, they did.
And they did ask you if you would take a breathalyzer, true?
True.
Because you did tell them that you had not drank any alcohol, true?
True.
But it wasn't true, was it?
It was not.
So were you scared?
Yeah, I was scared.
Or nervous? Or like, do you normally just lie? I'm not trying to be funny, but you would just immediately lie like you're 12?
No, ma'am.
So you just were nervous and didn't want to let on that you'd had anything to drink.
Correct.
And in fact, they took you into custody and you went to the jail?
Yes, ma'am.
And you didn't take that breathalyzer either because you were concerned or nervous or anxious or whatever. Fair?
Fair. Yes.
And then they eventually get blood. They take blood right from your arm.
Yep.
Do you have to go to a hospital to have that done, or do they do it right at the jail?
They did that right at the jail.
And I don't know if it was weeks later or when, or you talking to your attorney, Mr. Miller, but at some point you realized what the test result was. True?
Yes.
From the blood test, I mean.
Yes. Correct.
And it showed that you were over the legal limit, correct?
Correct.
Do you doubt it when you look back on this? Is that why you were worried about telling them, give me a breathalyzer right now?
Yes.
You thought maybe if you waited or had more time, it would work in your favor?
Yes.
Well, that's fair enough. I mean, it causes some problems with your driver's license when you don't take it.
Yeah. It
Have
sure
you
did.
felt that? Have you felt that yet through the Secretary of State?
Yes.
Yeah, because that's automatic with not so much the PBT at the scene, but the one down at the jail when you don't take that. The implied consent violation, they call it. And I don't know, I'm thinking like if you really had not drank a drop, just take the breathalyzer. If you really hadn't drank, you know what I mean? So then the officer's probably pretty much on to you that you weren't telling the truth about, I never drank anything tonight. You know what I mean?
Absolutely.
Do you have kids, Mr. Larrabee?
I do.
How many?
I have 2 children,
What are their ages?
8 and 10.
Okay, that's like 4th grade and 2nd grade?
Yep. 2nd grade and 5th grade.
2nd and 5th? Okay,
Correct.
the only reason I bring up your kids, and I didn't know you had them until you told me, I didn't know. The only reason I bring them up is for you to think about what could have this, how this could have ended up being so much worse than what you're going through right now. Not saying this isn't hard, I'm sure it is, and I'm not saying it's easy. But comparatively speaking, the fact that your wife or your other partner or whoever's the mother doesn't have to sit down with those kids and tell them a sad tale about what happened to dad. I mean, thank God it was just a blown tire and that's it. Last week, Friday, we had 2 fatals. And you're up in Sparta, aren't you? when this happened?
Yes.
Yeah, one of mine was up in Sparta. It wasn't just recent, but the case we had was Friday. Look at your case was March, so, you know, some of the cases we're getting are kind of older, but these fatals, I'm telling you, and I've been a judge for 30 years, but I'm so affected by those fatals. They are so hard when you have to talk to the people. I mean, you read it in the newspaper and then you put it down and drink your coffee or something. But when you have the people deal with it and you have to talk to them about what happened and you got to hear about who died, I don't know how we're supposed to tell. And your kids at 8 and 10, way old enough. 5th grade, 2nd grade, seriously, they're way old enough to understand this. At some point, you ought to sit down with them. Boys or girls, I don't care. You should sit down and talk to your kids about how you made a series of poor decisions that night. They love you no matter what. I'm sure you're a great dad. This does not make you a bad dad, but missing the opportunity to sit down and talk to your kids about what you experienced yourself by making a series of poor decisions could be huge in the life of your kids growing up. And I mean, we don't now because of COVID, but I love having kids come out here, the classes. You should hear their questions. The kids that are the age of yours. I have 2nd graders are my youngest group on field trips. Not during COVID, of course, but you know, when times are regular. And these 2nd graders, you should hear their, well, you know, because you're a dad of one, a sharp 2nd grade kid who they're smart as a whip. And sometimes we don't give them enough credit for how much they understand. And I'm just suggesting, because they hear stuff in the news, they see stuff on the news or read the paper, or you know, maybe they don't read the paper, but they see it on the television, you know, car accident. Maybe they hear about somebody at school that mom or dad, somebody got in a car accident. I'm just saying they could learn from you being honest about how you put yourself through a difficult scenario. And you are so lucky that you get a do-over. You get a do-over. Nothing happened to you, nothing happened to anybody else. But it could have been a completely different story. That's my only point. Mr. Miller, I'll ask you whether you believe the court has complied with the court rule in terms of the taking of the plea on the OWVI.
The court has, Your Honor.
So I wasn't exactly positive whether you got an assessment, Mr. Larrabee. Did you go anywhere and have an assessment done?
I did a phone assessment.
Okay. All we want to do is get the report from where you did your phone assessment. They do it now, you know, virtually because of COVID. So we'll just get the report from the phone assessment that you did. And you can follow up on that, Mr. Miller, or whatever you need to do, but I haven't seen a copy of it, but I'm going forward with sentencing right now. So what do you want to say at all, Mr. Miller, on behalf of your client?
Well, Your Honor, through my research, Mr. Larrabee doesn't have a criminal history. He obviously made a bad choice at a work party. And I see him as an extremely nervous person. I think what you just explained to him was great, and I think he needed to hear it. And I don't think you'll see him again. He came in as he does not meet the criteria for a substance use disorder. However, it's recommended that he attend a highway safety and drug education course. It sounds like he was open and a goal-oriented person. It was his first alcohol-related charge. I would ask the court to, based on his assessment and based on the findings, order that he do the alcohol highway safety class and the drug education course. And again, I don't have anything else on him in my notes that would reflect that he needs a higher sanction. And it sounds like he doesn't meet the criteria as a substance use disorder. So based on that, I'd ask the court to schedule sentencing accordingly. Thank you.
All right, I appreciate it. Can you think of anything, Mr. Larrabee, that you want to say?
Just thank you for what you just said, and you know, it hits home.
Yeah. Well, the minute I can talk about your kids, and I mean, I ask people all the time. I don't have kids myself, but I can ask people, and when they tell me they have kids, I make my point immediately. I mean, any decent parent, I make my point immediately. You know what I mean? So, and I'm not trying to be melodramatic. I mean, you probably, if you go through your life, you're going to remember kids or people that you knew back from high school, or somebody's mom was killed in a car accident, or you'll hear about it, and it's tough. So all we want to do is make sure it doesn't happen, and you're smarter than this, quite frankly, Mr. Larrabee. You're smarter than how you got yourself into this. It's a 93-day suspended jail sentence. You don't serve any more jail than the night you went to jail. So held over your head is 92 days, and we just hope that that won't need to be done at all. 5 days of community service, 1 year of probation, no alcohol, no illegal drugs, no misuse of prescription medication, no marijuana, testing regularly, counseling as ordered, follow the rules that they're talking about, just like what Mr. Miller has said. Your probation officer will work with you on that directly. You know, it'll all be done virtually, so not to worry. $560 in fines, $360 is the probation fee at $30 a month times 12. $75 crime victims' right fee, $275 goes back to the Sparta Police Department, and the total for everything on this is $1,270. Any bond money that was posted can be applied. And you have any questions that stand out, you can talk directly with your PO, that's the probation officer. Anything else comes up, you can talk to Mr. Miller, but really, I think you're going to be in good hands with your probation officer out here and just get everything taken care of. Okay? Mr. Larrabee, anything else?
No, ma'am.
All right, Mr. Miller, thanks for zooming in all the way from Florida. Appreciate your courtesies on that, okay?
Thank you.
All right, thanks.
Does he need to get a hold of a probation officer then?
Nope, they'll contact him.
Okay, I appreciate it.
All right,
Thank
thanks a
you.
lot. You bet.
Have a great day.
Let's see if Mr. O'Keefe is available. Mr. Lay, we're still trying to connect with Mr. O'Keefe, so just give
I'm
me a
here,
second.
Your Honor.
Oh,
Can you
good,
hear me?
thanks. Yes, I can now. Patrick
All
O'Keefe,
right.
thank you.
Good to see you,
Mr.
Judge.
O'Keefe, yes, we have Mr. Joshua Lay at the Kent County Jail. You probably see him on Zoom. I'm
Right.
Judge Sara Smolenski. Our two cases that we're talking about, one is a illegal use of a financial transaction device from June 26th. It's file D20-01900FY. And that other case was later in June through September in front of Judge O'Hara, conducting a criminal enterprise, a 20-year felony that was also set for a preliminary hearing today, both the probable cause conferences on both of these, and I'm taking both cases. Now, Mr. O'Keefe, I know that you've been talking with Mr. Nick Christensen from the Kent County Prosecuting Attorney's Office, where there are going to be continuing negotiations in circuit court on all pending charges. That Mr. Tarango from the prosecutor's office talked to you on the illegal use of a financial transaction device as charged, no objection to the Holmes Youthful Trainee, and that the continued negotiations is probably, if Mr. Lay waives on both cases continue to circuit court for you, Mr. O'Keefe, to continue to negotiate with the prosecutors. Is that your understanding up to this point, Mr. O'Keefe?
Yes, it is, Your Honor.
Your Honor,
Okay.
if I apologize. I just have to ask a question on that. As of right
Yep.
now, Mr. O'Keefe did retain in on the first case. I have in my hand, and I apologize, Mr. O'Keefe, I just got this yesterday, late, the substitution on the case D20-2467FY. I did execute that, and I can send that to the court as well. I just want to make sure that the court knows that I'm off that case as well.
Okay, so the way we look at it, Mr. O'Keefe, and you can tell me if I'm incorrect, the defender's office may have been appointed to one or both, but they're completely off both and you're on both, correct, Mr. O'Keefe?
Yes, that's correct, Your Honor.
Okay.
So, Mr. Schmiel, you're free to disengage and send in the paperwork on the substitution, that's fine.
Thank you, Your Honor.
Thanks for bringing it to the court's attention. So Joshua Lay, I know you're listening and you've been seeing us all talk about your cases and you're the one sitting at the Kent County Jail. I'm sure it's not easy and I get that, but you're in good hands with your attorney, Mr. Patrick O'Keefe. He's going to continue talking to the prosecutor on all your charges, the two cases that you have with us and anything else. If you waive your preliminary exams, That means there's no testimony on these two cases in front of me. The two cases move on to circuit court for continued and further negotiations. We enter a plea of not guilty, Mr. Lay, on both cases that you have with us. So while the cases move on to the higher court, which is circuit court, and you'd have a different judge, we'd enter a plea of not guilty for you. So there's two papers on each file that Mr. O'Keefe is going to get. One's called the waiver of the preliminary exam. One's called the waiver of the circuit court arraignment. The circuit court arraignment, Mr. Lay, is when you go in front of the circuit judge to hear what the charges are, what the penalties are, and what your rights are. We completely eliminate that by waiving the circuit court arraignment and allowing me to just say not guilty on your behalf for both cases, because you already understand what you're being charged with. Now, any questions that you have at all, Mr. O'Keefe?
No, Your Honor.
Okay. So, I think that's pretty much what Mr. Christensen was saying in his motion, was it not, not motion, but his email, Mr. Tarango and Mr. O'Keefe? I haven't read this paragraph that Mr. Nick Christensen sent, but I think he's saying, can Judge Smolenski do both waivers on Judge O'Hara's case and Judge Smolenski's case? Fair enough?
Yes,
That's my understanding, Your Honor.
All right, and that's what we'll proceed to do, Mr. O'Keefe. My clerk, Amanda Dubay, is going to be emailing you the documents, waiver of the prelim, waiver of the circuit court arraignment on both files, Judge O'Hara's court and mine. You process those, assuming you have authority from Mr. Lay to sign his name.
I do.
Mr. Lay, you already covered that with him, so that's good?
Yes, Your Honor.
Okay, fine. So, Mr. Lay, I would just tell you to keep talking to your attorney, Mr. O'Keefe, if you have questions that come up, because it's hard sometimes to remember everything you want to ask, and you think of it later. But that's why you have a good attorney, and Mr. O'Keefe will be representing you throughout this, okay?
Yes, Your Honor.
Okay, thanks, Mr. Lay. Mr. O'Keefe, my clerk Amanda will be sending those to you, and then you send them back to us. It'll be 4 documents altogether, 2 waivers of the prelim, 2 waivers of the circuit court arraignment. Do you want to address anything regarding bond, or are we pretty much set on that?
Yes, Your Honor. Obviously, that's one of the things that we have to consider at the probable cause conference, which is set for today on the FTD file, but was not set for today on the criminal enterprise file. However, we appreciate the court. We appreciate the court being willing to handle these files together.
Sure.
Your Honor gave Mr. Lay a personal recognizance bond on the FTD case on or about September 18th. And then I think subsequent to that, after he was arraigned on your case, the police picked him up on this continuing criminal enterprise case. I don't have a lot of information, Your Honor, but it would be, I guess, my inference that the criminal enterprise more than likely involves some stolen property, perhaps some pawned property, perhaps some financial transaction devices. And I say that because Mr. Lay is 18 years old. He is currently set, Judge O'Hara set a $50,000 cash or surety bond as
okay, that's what I wanted to know, yeah.
And that's what I was told by my client. I have no reason to disagree with that. But Your Honor, he is not a likelihood to fail to appear in court. He has a couple of juvenile adjudications on his record, one being an assault and battery when he was about 14 or 15 years old. He got in a fight at school. He was adjudicated for that. He was also adjudicated for a larceny over 1,000, and I believe another larceny type offense, misdemeanor type offense as a juvenile. Right. As far as convictions are concerned, Your Honor, that's the extent of his criminal history. He's currently living with his mother, Dusty Lay, and I spoke to her yesterday. She indicated that she would like him to come home and live with her, and she's indicated that she will do whatever is necessary to keep tabs on him. I talked to Mr. Lay yesterday about putting him on a GPS tether, and he is in agreement with that if the court is so inclined to put him on a GPS tether. His mom works full-time. I think she works in a factory. She's a single mom. She's got at least 3 kids, I believe, all of Native American heritage. And she just simply can't afford to pay his bail on top of candidly paying me for his 2 cases. And so $50,000 is just too steep for his mother to post. And not only that, Your Honor, I don't believe that it's necessary to guarantee that Mr. Lay continues to appear in court. I don't know that he has any FTAs in his history. He may have one FTA from one of his juvenile cases, but otherwise, I don't see any indication that he's likely to fail to appear in court. So it also does not appear from the pretrial bond screening report that he has any kind of substance abuse issue, that he has any kind of drug or alcohol issue. He does have some special needs. He does have a psychiatric history. I believe he's been either in Forest View or Pine Rest as a young kid before. His mom has verified that he, unlike his siblings, has had mental health challenges. And so that's why I would really like to get him home with his mother. And I like I said, she's a very hard worker, and he indicates to me that he's a very hard worker, and that he learned that from his mom. So I expect that he's going to end up getting a job very soon as he's released. I'd like to get him back to work, Your Honor.
Right. Okay. Thank you, Mr. O'Keefe. I noted in Mr. Tarango, if there's anything you want to add, you're allowed to, but I noted that with the court services report that Judge O'Hara saw on his case, that Mr. Lay was on probation out of Wyoming for a shoplifting case. He was out on a PR bond for a retail fraud first 5-year felony out of our court, and he was out on another retail fraud third bond 500 PR out of the 62A district court. That looks like that's separate than the probation case. When I was looking at the court services report, they were not recommending a PR bond. And I get that the mother is doing everything she can, although none of this is her responsibility. When she's working full-time, it's a concern to me how much supervision there is. But what I'm going to do is change the bond from a $50,000 cash surety to a $20,000, 10%, with the GPS tether. So it would be a $20,000, 10% with the GPS tether. Now, that allows you, Mr. O'Keefe, if you need to continue at circuit court about that bond if there's going to be any changes from circuit court. But I'm still feeling like we're staying in line with what court services recommended, not a PR bond, but it is a monetary bond with a GPS tether so that the location of Mr. Lay can be monitored at all times.
Thank you.
Okay, Mr. Tarango, I didn't give you a chance to speak, and I should have. Do you have anything you wanted to add or say?
No, thank you, Your Honor.
Okay, all set then. Mr. Lay, you just keep talking to your attorney. He'll explain what's going on. Okay?
No.
All right, thank you.
Thank you, Your Honor.
Okay.
Is that it?
Yep, that's it for right now.
Hello?
Can you tell me who you are? Identify yourself.
Rachel Wolf.
Yep. Ms. Wolf, I have your case and I'm going to be with you in 1 second. I'm Judge Smolenski. Give me a second.
Okay.
Go ahead.
I got John with me too.
You've got Jonathan Richardson with you?
Yep.
Okay, hang on. I'll be with you guys.
All right, thank you.
Mr. Tarango, I was wondering if you had any chance to talk to Jason Barracks on that Coster case?
I'm looking, going through my emails, because I was just noticing that. Your Honor, I have an email from Mr. Barracks dated October the 1st. His email states, I read the offer. I was hoping for a plea to 1 count to waive. If there's a reason you need him to plead, well, That's talking about the negotiations.
Uh-huh.
The last,
Maybe what I'll do is try to see if I can get Mr. Barracks by telephone.
the last I,
And see, go ahead.
the last I have is an email saying, thanks. Basically, we will appear tomorrow. If you need anything more, please let me know.
Well,
So,
it's funny because the case was at 9:15 and we haven't heard from him, and now it's 10:30, so I
Right.
don't know what the deal is on that. But let me get back to him on that. Let's do the people that are on the Zoom and are here. And that's Jonathan Richardson and Rachel Wolf. Now, Mr. Liss, who do you represent?
I represent Ms. Wolf, Your Honor.
Okay. So, Ms. Wolf, can you still hear me okay?
Yeah.
Thanks for zooming in. I appreciate it as it relates to the cases that you have. There were the felony case that you had with Mr. Liss representing you, Ms. Wolf, was the 20-year felony with the charge that they called operating or maintaining a laboratory involving methamphetamine. That's what was scheduled for today. There was a pretrial that you had on a 90-day misdemeanor B&E illegal entry without owner's permission. And that case goes back to an incident March 14 on East Fulton Street in Lowell. But then now we've got a new charge that you may not have heard about, a retail fraud 3rd degree, a misdemeanor out of the Lowell Meyer. And they're talking about September 17, Ms. Wolf. Retail fraud 3rd degree is a misdemeanor, up to 93 days in jail, up to $500 fine, or 3 times the value of the property stolen, whichever is greater. On that retail fraud 3rd from the Meyer in Lowell, September 17, which is about 2 weeks ago, you can plead guilty or not guilty. You can have a trial in front of a judge or a jury. You can have an attorney represent you. Mr. Liss is representing you on these other cases. We'll have to find out if he's going to represent you on this one, but you definitely still have the right to have an attorney represent you. If you wanted to have a trial, you could bring in witnesses, cross-examine witnesses, take the stand yourself, be a witness if you wanted to. If you chose not to, your silence cannot be held against you, and you have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Now, so far, can you think of any questions that you have, Ms. Wolf?
No.
On that retail fraud 3rd degree charge at the Meyer in Lowell, we're just going to enter a plea of not guilty on that. If there was something that you wanted to appeal, you're given 3 weeks after being sentenced to appeal to the higher court. Now, Mr. Liss, you've talked with Mr. Tarango about the current felony case and the one misdemeanor that was the B&E illegal entry, and you didn't perhaps know about the other retail fraud that I just arraigned her on. Where are we at with the discussions that you guys have had?
Your Honor, I believe pursuant to a plea offer that I received yesterday, and I believe it's been confirmed by Mr. Tarango again, is that the offer is a creation and delivery of a counterfeit substance Schedule 4, which is a 4-year felony, along with the B&E illegal entry without owner's permission.
Which is the misdemeanor.
It's a 90-day misdemeanor. I'm not sure what Mr. Tarango wants to do with the retail fraud 3rd. If he wants to include that with these cases, I'll take it for further negotiations when we get up to circuit court, but I'll defer to Mr. Tarango on that.
Okay.
And upon successful plea and sentence, the 20-year operating or maintaining a lab involving methamphetamine would be dismissed, as well as the supplemental information. That's the plea as I understand it right now, Your Honor.
So really, technically, with all your discussions with Mr. Tarango, it didn't include the misdemeanor on the retail fraud that I just alluded to from the Lowell Meyer, but that there was an intention to keep the offer open on the 2 cases that you have with Ms. Wolf right now, as to the plea agreement you mentioned, and have the case move on to circuit court.
That is correct, Your Honor.
So really, Mr. Tarango, you could continue your negotiations with that other misdemeanor retail fraud, still with this case continuing as a waiver and going on to circuit court. Fair enough?
fair enough, Your Honor.
Do you feel like you get that, Mr. Liss? All we do on our misdemeanor retail fraud is hold it until you guys finish some of your discussions on this at circuit court, and let us know if it impacts that case or not.
I understand that, Your Honor. Just for paperwork wise, if it's set for a pretrial, sometimes those notes don't make the misdemeanor file, and then all of a sudden there's a bench warrant, and I just hope.
Why don't we appoint Mr. Liss on that retail fraud third? That way you'd be in on all of it.
Fine, Your Honor.
And
Will send me notice as to when the pretrial is. I can put it on my
Yeah.
document calendar.
Okay, that's fine. Go ahead, Mr. Tarango. What else did you want to say?
I was thinking I could add on the offer sheet, discussions on the retail fraud as well. That way they can take the B and E, the retail fraud, along with the felony up in circuit court.
Yeah,
That's fine with me, Your Honor.
okay, that's fine. So Ms. Wolf, a lot of talking and a lot of discussing, but what Mr. Liss went over with you earlier was that if you waive your preliminary exam on this felony case, the case moves on to circuit court. The other cases are going to be kind of tied to it and further discussions on all of them. Do you understand that?
Yes.
Also, if you waive your preliminary exam, there's no testimony taken in our court in front of me. In essence, really, there's nothing for me to decide on. The case automatically moves to circuit court, and you and your attorney will continue negotiating and discussing it until you ultimately make a decision. Are you with me on that?
Yes.
Do you feel like any questions pop out for you, Ms. Wolf?
No.
The only thing I wanted to say is that, and I'll be saying the same thing to Mr. Richardson too, but when this case moves on to circuit court, there's two documents that Mr. Liss is going to be needing to sign on your behalf. One is a waiver of the preliminary exam on that felony drug charge, and the other one is a waiver of the circuit court arraignment. The circuit court arraignment just means you don't go in front of the circuit judge to be arraigned. It allows me to say not guilty for you as the case moves on to circuit court. So if you give Mr. Liss your permission to sign on your behalf for those two documents, waiver of the preliminary exam on the felony case, waiver of the circuit court arraignment, it just allows me to say not guilty, and you don't have to have another court appearance or Zoom appearance. Are you with me on that, Ms. Wolf?
Yeah.
And you give your
Yes, I am.
authority to Mr. Liss to sign those two documents on your behalf?
Yes, I do.
Okay, on that misdemeanor retail fraud, it's just a $500 PR bond. I don't have you held or anything like that. But I did sign a document, Mr. Liss, where I want you appointed, so you'll talk and you guys discuss that as Mr. Tarango has indicated, okay?
Thank you, Your Honor.
All right, so Ms. Wolf, that's it for you. You can certainly stick around and listen as we talk to Mr. Richardson, probably pretty much the same thing. But if you have any other questions or follow-ups or things come up, Ms. Wolf, you know you need to call Mr. Liss directly, okay?
Okay.
Okay. Now, Mr. Jonathan Richardson, you're right there?
Yes, ma'am.
So, Mr. Richardson, I'm Judge Sara Smolenski, and I have you in front of me with your attorney, Mr. Marcus Schmiel. And that's on the felony case, which is D20-02352FY, charged as a co-defendant with Ms. Wolf on operating or maintaining a laboratory involving methamphetamine, the 20-year felony. In addition, we had the pretrial today on the misdemeanor illegal entry without owner's permission, also charged exactly like Ms. Wolf, a misdemeanor case on the incident that was March 14th at the East Fulton address, and then an arraignment today on the charge of the retail fraud. Same case that we were talking about with Ms. Wolf, but a little bit different charges for you, Mr. Richardson, so hear me out. One is a misdemeanor called deactivation or removal of a theft detection device, where they allege that at that Lowell Meyer on September 17, that you did deactivate a theft detection device or remove a theft detection device from any merchandise in a retail establishment with the intent to commit or attempt to commit a larceny. That's the misdemeanor, 1 year in jail and or $1,000 fine. And then in your case, they charged you with retail fraud second degree, at that Meyer store on that date of September 17th while the store was open to the public. They're alleging you tried to steal property of the store that was offered for sale at a price of less than $200. But because you have a prior conviction in the summer of 2014 out of the 64A district court, which would be Ionia, they bumped this up to a retail fraud second. So the misdemeanor is again 1 year in jail and or $2,000 fine or 3 times the value of the property stolen, whichever is greater. And we can appoint an attorney to represent you on this. And Mr. Schmiel, I'm sure it's going to be your office on this. You have the right, Mr. Richardson, to plead guilty or not guilty on those 2 charges from Lowell Meyer. You have the right to have a trial in front of a judge or a jury. You have a right to have an attorney. If you couldn't afford an attorney, the court could appoint one for you, like I just said. And if you wanted to have a trial, you could bring in witnesses, cross-examine witnesses, take the stand yourself, be a witness if you wanted to. If you chose not to, your silence cannot be held against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. Can you think of any questions that you have so far, Mr. Richardson?
No, ma'am.
Are you on probation or parole right now besides what we're talking about today?
No, ma'am.
If there was anything on this misdemeanor charges from the Lowell Meyer that you wanted to appeal, you're given 21 days from the date of sentencing to appeal a case to the higher court. You understand that?
Yes, ma'am.
When Mr. Schmiel, your attorney of record, was talking to Mr. Tarango on your case, as well as the case with Ms. Wolf, quite frankly, there was discussion that if you waived your preliminary exam on that felony drug charge, that the plea offer would be creation, delivery of a counterfeit substance, Schedule 4, and B&E of an illegal entry without owner's permission. That there'd still be further discussions at the circuit court, presumably, as the case moves on. Is that your understanding, Mr. Tarango?
Yes, Your Honor. And also, I mean, obviously, we would dismiss the operating, maintaining drug labs.
The original 20-year felony would be dismissed.
That's correct, Your Honor.
Okay. And Mr. Schmiel, is that what your understanding was?
I'm a little bit confused, Your Honor, to be honest. I have before me on the felony complaint 1 felony charge of controlled substance operating, maintaining a meth laboratory. I have no idea. Yes, I have no idea what the illegal entry charge is.
Okay.
And I'm just what the court has stated on the retail fraud is what I have knowledge of on, or the removal of the theft detection device is what I have knowledge of on that matter as well. I would just ask that we would be appointed to those matters. And to be honest with you, I have not spoke with Mr. Richardson. His phone number that was listed in the police report was redacted for some reason. I'm not sure why that was. So I haven't even had the opportunity to speak with him.
Would it be helpful right now if we put you in a separate room with Mr. Richardson just to go over this? I can appoint you on the illegal entry case that's a 90-day misdemeanor, charged as a co-defendant with Ms. Wolf. But before you guys make any final decision today about waiving this felony preliminary exam, for you to talk for just a minute with Mr. Richardson?
Yes, Your Honor, I would appreciate that very much.
All right. I've got another case I'm working on, so if we don't bring you back immediately, don't be worried. We'll get you.
Thank you.
Okay. So hang on, Mr. Richardson. You're going to get notification of being invited to a breakout room, and then you'll be back to talk with me. Just Mr. Richardson and Mr. Schmiel. I signed them. Well, Is it CHMIEL? Mike, what case are you zooming in on?
The low credit rents.
Yep. And what's your last name, Mike?
O'Dowd, O-D-O-W-D.
O'Dowd?
Yep.
Yep. And are you connected with Velo?
Yeah, they're my attorney.
Yep. And you're the owner of Low Credit Rents?
The general manager.
Okay. And have you seen any of your representatives zoom in or on that?
For Velo?
Ms. Chappis is here. Ms. Chappis is here on the case for Ray John. Right, Ms. Chappis?
Yes, Your Honor.
Yep. And have you seen anybody for Velo, or I'm not sure what attorney, is it Scott Renner that we're waiting for?
I'm not sure who they were sending. I know my client, the defendant, had texted, and I think she might be in your waiting room.
Okay. I'm
maybe
working on
Mr.
a,
Runner or someone is there.
sure. I'm working on a felony prelim right now, and I've got them in the waiting room too, so I'm gonna be with you here shortly. But Mr. O'Dowd, is it O'Dowd?
Yes, I can call the attorney
Yeah,
and see
just
where they are.
mute yourself and call to see what attorney from Velo, this is probably him.
Yeah, that.
Mr. Kosmarek, are you with Velo?
Yes, Your Honor.
Calling in on that low credit? Okay.
Yes,
Low
Your
credit rents? Yeah. It was set at 10:30, wasn't it? I'm just asking because we've been busy with other cases, and I'm working on a felony criminal case right now where they're in a conference room, and Mr. O'Dowd has been on for a while. Anyway, so are you, Ms. Chappis, going to need to talk to Mr. Kosmarek at all, or not really?
Certainly if he would like to talk, I'll always talk. But I think it's pretty, Ms. John had filed a motion, and I think since then she's learned more about the CDC declaration. We've reviewed it. I do believe it applies to her circumstances. So she's executed that and delivered it. So I think our issue today has sort of mutated a little from what her motion said.
Well, let me just put on the record the case that we're talking about so everybody's on board since I'm waiting for this other one. D20C02902LT. We have attorney Kosmarek, who's representing Low Credit Rent. We have their office manager or property manager, Mr. O'Dowd. And then it looks like Ray Lee John is on our Zoom. Ms. John, can you hear me?
Yes, I can.
Okay, great. So we've got everybody on, and it was originally a motion that was filed when Ms. John was representing herself, although it looks like clearly she had some assistance in filing her motion. Now she's represented by legal aid, and her original motion was to quash the eviction. In the meanwhile, we've got the CDC declaration that's been filed, which is really requiring a cease and desist from all actions in the district court, although there are a lot of rules and criteria that the court doesn't have committed to memory. I think this is my second one that we have now that we're working with a CDC declaration. And if there's anything, Mr. Kosmarek or Ms. Chapkus, that you could present to the court by way of any written brief about how the declaration impacts it. What I'm hearing Ms. Chapkus is saying right now, it makes the motion kind of moot because it stops everything, almost like a stay. I think of it almost like a stay in bankruptcy court. And the expiration, I believe, is the end of the year. And right now, the way our court is handling them is when we feel like we have a valid CDC declaration affidavit signed by the client that we just cease and desist action on the case. We put it off for a date that's going to be past the expiration, which would be the first of the year. Of course, most of the time on the first of the year, none of us are working because that day itself is a holiday. It would be that first week of the year. I don't know exactly what date. Mr. Kosmarski, is there anything that you can think of that you want to say as it relates to just what I'm addressing right now?
It's Kosmarek, Your Honor.
Oh,
Would
sorry,
you like a brief on the
Kosmarek,
issue?
my bad.
Would you like a brief on the issue? Because I don't believe that the CDC order applies in this case.
Yeah, it would be helpful for me if you would. And then I'd like you to have it's your motion, I mean, it's their motion originally to quash. So I guess I don't want you to not be able to respond to each other. Ms. Chapkus, if you can just present a brief to the court why you believe it complies, and Mr. Kazmarek maybe get a chance to look at that and then respond. If we could do something like that, or you both can send your documents in. I'm just telling you right now, I'm choosing not to go forward with any action until I know for certain, which is exactly what I said on my first case yesterday afternoon. Does the CDC declaration affidavit apply so as to cause a timeout or a stay? And I left that after 45 minutes on that case, not so unlike this one, quite frankly. And I spoke to my colleague, Judge O'Hara, because obviously all the courts are getting these, and we're going to all have to figure out how to deal with them. But right now, I'm just saying status quo. Think of it as an adjournment of the motion to quash. We're not hearing it today, technically speaking. Get your briefs in on the CDC declaration application, if you will. Does it apply? Does it not? How do you think it does? How do you think it doesn't? And then I can go from there. What it probably means is we're going to adjourn this a couple weeks out. So if you guys have 2 weeks to get me paperwork on that, your best brief in argument of the CDC declaration, I've always thought of it as the whole point of that is to stop the spread of coronavirus. It's not about do people have money to pay their rent or do they not. It's not the eviction diversion program. It's not. It's completely separate. It's picture a mother with 5 kids who's being evicted. It's to stop the spread of coronavirus. That's how I look at it. I'm happy to be educated about your take on how you both review it and whether the specific criteria, if there is criteria, has been met to put a stay into effect. Right now, I'm just saying status quo. Think of it as an adjournment of the motion. No actions, no escrow, no anything until I get those 2 briefs. Questions, Ms. Chapkus?
Yes, I would just, in terms of focusing briefing and not having to brief every single item, which would then make the court have to read something very long. If I could understand, or if there is a short statement that plaintiff could tell me what the dispute is or why they think this tenant is ineligible, we could then maybe focus our briefing and get to the core issue.
Yeah.
That's fair. Go ahead. Mr. Kazmarek?
So when you're reading the plain language of the CDC order, it provides that it applies that a landlord cannot evict a covered person during the period of the order. Here, a covered person is defined as
okay,
one
without going into the details of that, your position is she's not a covered person.
No, she is a covered person. The question is one, does the CDC order apply retroactively because the affidavit that is required under the CDC order was not submitted until 9 days after this court issued the order of eviction. So
okay.
My position is that it's untimely. Does it apply?
It's the timeliness of it.
What's that?
It's the timeliness of it because the judgment was already ordered.
The judgment and the order of eviction had issued.
Okay.
So my client was entitled to possession of its property, and then the CDC affidavit was provided.
Okay, that's fair. That narrows it down right there, Ms. Chapkus.
It does, thank you.
All right. So then 2 weeks, get your written briefs in and we'll reschedule from there. I'll let you know from my clerk whether we're gonna have to Zoom in again or whether we're gonna do a telephone conference. I'm not really positive, but let's just look at it and then take it from there. Mr. O'Dowd, I'd just say you be in contact with Mr. Kazmarek so you know what's going on with them, okay?
Okay, thank you.
And Ms. John, you just stay in contact with Ms. Chapkus.
Yes.
Okay? Okay, everybody, thank you very much. On that low credit rents versus Ray John, you guys can all disconnect. Thank you.
Thank you.
Okay, so Mr. Schmiel is coming back right now. And we're waiting on Mr. Richardson. I think he's going to come back in.
If he does not, Your Honor, he was his phone was having a lot of trouble and it was disconnecting, connecting. He did give me permission to sign on his behalf. We did discuss the
Did you
matter.
talk to him during your meeting? Yeah, he's
Yes,
coming
we
back.
did. We did get the opportunity to speak. Thank you, Mr.
Okay.
Richardson. I didn't know if your phone had issues. At this time, after speaking with my client, we'll be waiving the right to preliminary examination. I have executed both of those documents. Mr. Richardson has gave me permission to sign on both of on his behalf. I would just ask the court to appoint us on both of the misdemeanor cases so we can look at that. Mr. Triangle, are we putting on this anything on this pre-exam conference form about that retail fraud third, or you just want to note that in your file?
To me, the easiest way is just to combine them all, the retail fraud and the deactivation device, with this current felony charge, and that way you can deal with all of them as a package deal in circuit court. That's
fine.
Yeah, except, yep, that's good. Except that our misdemeanor cases physically won't move to circuit, but they can be part of whatever discussions or negotiations you guys have. But I am appointing your office inspect, specifically you, Mr. Schmiel, to both those misdemeanors. So there's 2 new misdemeanors on Mr. Richardson. That's the retail fraud and the theft detection device. And then there's that other 90-day illegal entry that was the same case that Ms. Wolf had.
Your Honor, may I please have the number for the theft detection device case?
Yep. It's D20-02503. And it's 2-count misdemeanor, theft detection device, retail fraud second, both 1-year misdemeanors. And the location was the Lowell Meyer, September 17 this year.
Sorry, Judge, can you give me that file number again?
D20-02503-SM. And then just for purposes of clarity, the illegal entry 90-day misdemeanor, of which both Ms. Wolf and Mr. Richardson were charged as co-defendants, is D20-00949-SM. 1 count, illegal entry, 90-day misdemeanor.
Okay,
So then
Mr. I
Oh,
apologize.
sorry. No.
Mr. Tarango, I'm just so we're all on the same page here. I put on the form that we've executed the original charges, and I added on the language, dismiss original complaint for the negotiations on theft detection device cases D20, and listed both of those case numbers on there just so everybody's on the same page. Is that okay with you?
That's fine.
Okay.
What I did, I just said to include the retail fraud second and theft deactivation device, put their numbers on there in negotiations.
Okay. So we can submit both of those. If Mr. Tarango, the only thing we'd be requesting at this time, if you could note for your file, would be the in-car videos of both the Lowell Police Department and the Kent County Sheriff's Department that were on scene during the time of the search.
For the felony?
For the felony, yes.
All right.
Okay, so Mr. Richardson, stick to talking to your attorney, Mr. Schmiel. We're going to go forward waiving the preliminary exam as you guys have discussed, waiving the circuit court arraignment waiver on the felony, so we can enter a plea of not guilty for you. There's no testimony taken. The case moves on, just like I was talking to Ms. Wolf about a few minutes ago. Do you remember?
Yes, ma'am.
Any questions that pop out?
No, ma'am.
And you do give Mr. Schmiel authority to sign those 2 documents on your behalf?
Yes, ma'am.
Okay, so if something comes up or question pops up, there's going to be a lot more meetings and discussions on your cases. Just talk with your attorney, okay?
Yes, ma'am.
And I know you're with Ms. Wolf, you know, I don't know if you live together or what, but make sure you guys don't go back to that Lowell Meyer. Just tell her too, don't go back to the Lowell Meyer. I said that before, but I just want to reiterate it again, okay?
Yes, ma'am.
Okay, that's it then, Mr. Schmiel. We're adjourned on this matter. Anything else?
Mr. Tarango, I apologize. The Lowell body cam as well, if they do have that on the felony case.
I'll just ask for all video related to it.
All right, thank you. Thank you, Your Honor.
All right, perfect. Thank you, gentlemen. Appreciate your courtesies. We're adjourned on this matter then. Thank you.
Thank you.
Mr. Tarango, I want to try to get a hold of Jason Barracks to see what's happening on that case, because I'm not sure exactly.
Did the court sign the substitution on that case as well, Your Honor?
I don't know if it got to us, but if it does, I will. I think it's downstairs somewhere. It got faxed over, but it hasn't connected with me.
Okay, so I'm free to leave on that.
Coster. You're off
Okay.
the Coster matter entirely.
All right, thank you, Your Honor.
Thank you. Amanda, do you know if Joseph Coster was in custody or not?
He's not.
We can schedule time to speak.
Mr. Barracks, it's Judge Sara Smolenski. It's almost 11 o'clock, and it's Friday, the 2nd of October. I'm calling on the Joseph Coster case, Koster. Originally, the defender's office was representing him. We are of the opinion that you substituted in on that case, although technically I'm not looking at the substitution right now, so I was just told about the substitution. Can you contact our court and let us know what's going on with that? Because we thought perhaps there was a waiver, but I'm not clear on it. I know that you sent Mr. Tarango some emails, and Mr. Tarango's been part of our Zoom meetings this morning, but he didn't, is it fair, Mr. Tarango, to say you weren't really 100% clear on how Mr. Barracks was handling Coster?
Your Honor, yeah, my understanding was that he was planning on showing up, but I could be mistaken on it.
Yeah. Mr. Tarango was of the belief, Mr. Barracks, that you were going to Zoom in with us. Well, the case was set at 9:15. We've been going straight out all morning, and it's 11 right now, and we haven't heard from you. So will you let me know what's going on? We need to know. I haven't heard from Coster either. I don't want to do a bench warrant. All right, thank you. Bye. Okay, well, let's wait to see what we hear, and maybe I can put something on the record this afternoon.
Okay.
I don't want to do a bench warrant right now if he thinks there was some resolution or whatever, but we still need to hear from him today. Okay?
Do you want me to just, I'll hang up from Zoom?
Yeah,
and
just, perfect.
call me when, or email me whenever?
Yeah, perfect.
Thank you.